All rise. The Court of Appeals Division 1 is now in session.
Good morning. Please be seated. This is the time set for oral argument in Ramirez Brothers Landscaping versus Industrial Commission. Our cause number is 1CA IC21-0011. Typically, when we do oral argument, we hear argument from both sides, but we do not have an appearance from Appellee's counsel, and I'll note that we've begun the argument 9 minutes late in an attempt to afford Appellee's counsel a courtesy. But that said, I won't have to admonish you about your rebuttal time. We can simply begin.
Thank you, Your Honor. Your Honors, may it please the Court, Fabian Zazueta on behalf of the petitioner Ramirez Bros Landscaping. Your Honors, with Appellee's non-appearance, I just want to make a record for the Court that this is a debatable issue that wasn't addressed in the answering brief. I just want to make a record that is a confession of error for what it's worth. Your Honor, I think this is a de novo review on the question of law. I think it's beneficial to address the seminal question, the dispositive question that we're here to answer today, and that is whether or not Ramirez Bros regularly employed workers. The Donahue case in 1993 established effectively a test, interpreted the statute ARS 23902A, and determined and concluded.
Counsel, I don't want to start picking nits here, but this is not truly a question of law. It's a mixed question.
Yes, it is, Your Honor, and the factual findings of the lower court are taken for what it's worth. There's deference given to the lower court.
It's more than what it's worth. We accept the factual findings as true and then apply those factual findings to the legal issue involved, correct?
Correct, Your Honor, but I will add that those factual findings...
Let's look at the facts here for a second, and you can answer for me a couple of questions regarding it. Roughly the employees, I'll call them employees, I know you have a disagreement with that, but I'm going to call them employees. The employees worked for your client for 5 months, correct?
The employee, Mr. Diaz, worked for 6 months and Mr. Ortega for 5 months. So August 2018, Mr. Diaz, September 2018, Mr. Ortega, respectively.
And during that, and I'll say 5 months, even though it varies, during that 5-month period, their testimony, which the ALJ found to be credible, indicated that they worked full-time. Sometimes overtime. Correct?
That's correct, Your Honor. And if I may add, we got to put some context here. This is a landscaper who has worked for 15 years as a sole proprietor doing a DBA landscaper, which sometimes had other projects, if you will, such as paving, some irrigation work. But Mr. Ramirez testified in the lower court that he didn't have time to do that stuff. So the context here I want to provide to the court is these projects are not a one-time thing. So these projects may have lasted 4 months, may have lasted 5 months. It's the appellee's burden at the lower court to show that they have a compensable claim. They didn't even get into those details. So these projects could last, like I said, it can be a homeowner who contacts my client and says, I have a project.
But you're not saying these projects are not related to the business that your client was engaged in, are you?
I'm not, Your Honor, but I think Donahue at paragraph 23 says all the other employees in the cases it analyzed said that those employees were actually working in the type of work that the employer was performing. In other words, if we're doing handyman work in Donahue, O'Brien is the employer there, the employee there was doing electrical work on a ladder and doing work that was in the scope of what was in Mr. O'Brien's line of work. If that answers the question.
Well, it is, but even then, it was within the scope of the work there, and it clearly is within the scope of work here. I mean, it's not like he was asked to do
computer programming.
Exactly.
Yes. Your Honor, I think that the answer to the question is yes, we're not answering that, but I think the analysis goes one step further. We cannot look at the job duties that they were performing. We have to look at whether or not the employer regularly employed these workers in the course of its business. And that was specifically addressed in Donahue. And that was also...
Well, I would understand that if you were talking about a week. Wasn't it 4 days in one of those cases?
Donahue, yes, Your Honor, was 4 days.
Okay, so we have 4 days versus 5 months. And after the injury, it's not like, oops, the 5 months over with, your client calls them up and says, would you like to work some more?
Your Honor, I know the answer is yes to your question, and the logic in your question suggests the answer is yes, but I will add that, again, this goes back to we have to analyze whether or not the employer had regularly employed employees, which has been defined as...
What more regular do you need to be than 5 months of employment?
And that goes back to the context, Your Honor. The context is this is a project-based type of work. The line of business here is this homeowner's contract with Mr. Ramirez, who has been doing this for 15 years by himself.
Well, what landscaping work isn't project-based? Isn't it all inherently project-based?
Judge Juan, yes, it is. I guess I will add, Ramirez Bros, Mr. Fernando Ramirez is the individual, and I'll refer to him as Ramirez Bros. Ramirez Bros testified uncontroverted testimony in the lower court that he would not do these extra projects, such as irrigation work. He would do pavers, landscaping, cleaning the front yards. This was all testified to at the lower court. There was no testimony showing anything controverting that, so the court couldn't have given it debatable issues, couldn't have given that in its weight because there was only testimony from Mr. Ramirez.
Well, let me ask you this. Where did the court clearly err in a factual finding?
Your Honor, so there was the decision upon hearing. I believe the court erred in skipping over the analysis in 23902A.
Well, no, I asked where the court clearly erred in a factual finding. You're making a legal argument. Are any of its factual findings clearly erroneous?
Yes, Your Honor. In paragraph 5 of the decision upon hearing, there's a large paragraph that goes into the exercise of control of the employees. The court goes into analyzing that Mr. Ramirez provided them a truck, that he put gas with his own credit card.
Is any of that false?
It's not false, Your Honor, but that presupposes that there's an employer-employee relationship, which we...
Well, no. I mean, it's evidence of an employer relationship. So the ALJ found that Mr. Ramirez provided a truck, provided tools, and did so over for a course of weeks during a 5-month stint during which these individuals were employed by Mr. Ramirez. Is anything I just said false?
Your Honor, no, none of that is false. But I think to answer that question, and what we, in small part, argued at the lower court, is that we're not arguing that they're employees versus independent contractors. And that might be true, but I think the court erred in failing to analyze the mixed factual findings of fact and law in the Section A, which is determining whether or not Mr. Ramirez is an employer subject to the statute.
So under Donahue,
Yes.
the employment here was clearly more extensive than the employment in Donahue, yes?
Yes, Your Honor.
Okay. So Donahue at best creates some sort of atmospheric test for you, but it's not an a fortiori case. We're actually here on worse facts than Donahue.
We are, Your Honor, and there's a case, and I can't recall the case, but there's a case essentially where the court, that it comes after Donahue.
Putz?
No, Putz dealt with, it's not Putz, it's another case, the more recent, I think it's 2021, and Black's Construction, I believe. But in that case, Your Honor, the court even addressed the fact that these guys were working, and those employees were working for an extended period of time. They were
Extended how long? In this unnamed case, extended how long? I couldn't find anything that came close to 5 months.
Your Honor, I apologize for not recalling the name, and I can provide any supplemental briefing on this issue if the court gives us leave. But essentially in that case, they were working, I believe, 32 days out of the year, and they were working, I think, anywhere from 2 to 3 weeks from those 32 days on a regular basis, consistent basis, so 40 hours a week type of thing. The court in that case said this is a close call. And analyzing putts, the court said we got to treat these cases on a case-by-case basis. There's no bright line test that we can determine from just the facts. Each case has to be given its facts.
But if 32 days is a close call and 4 days is okay, wouldn't 100 days pretty clearly be not a close call? And that's what we have here, really, is a record of roughly 100 days of continuous employment that would have gone on for longer had the accident not occurred.
That's correct, Your Honor. And I respectfully point the court to Putz, which said you cannot look at the relative percentages of the worker's work history. So, and Putz, in this case, just more specifically, and to get to the point.
It didn't say we can't look at it. It said it isn't determinative. And I think that's important because it's relevant in the determination of whether there's an employer-employee relationship. I mean, somebody who works 364 days a year, that is an employee. And it's determinative because we look at the ratio of days to years. As Judge Schwann's comment, 4 days, probably not. 5 months, 6 months, that is a factor to consider in determining whether or not there's an employer-employee relationship. Wouldn't you agree?
Judge McBurdy, yes, that is a factor to consider, and it's not determinative. The Putz case, I think, mentions it's indicia of a scheme of employment.
So what's the best factor that counters the inference arising from 5 months?
Let's look at the existence of Ramirez Bros. The Ramirez Bros has been in existence for 15 years, 6 months of them working for 15 years duration where there's no evidence of hiring other workers.
Business got good. I mean, things can change. Apple used to have 2 employees.
Your Honor, I agree, yes. However, we have to look at the intent of the employer, in my opinion. The intent here, and was testified by Mr. Ramirez, is that these individuals approached them. He only gave them work because they couldn't afford to put food on the table for their families. That's one factor to consider. The 15 years to 6 months comparison of relative percentages, I'm not good at math, but that's about 3% of the existence of Ramirez Bros that they've hired these workers for these Do I
really care what happened in year 1? Isn't it more relevant to look at what's happening in the current situation? I mean, I don't. Quite frankly, what difference does it make happen in year 1? He was just starting. We're talking about year 15. And in year 15, he had employees for half the year. Or at least people he was paying full-time wages, sometimes overtime.
I agree, Your Honor. It's important to look at what's happening now. But again, uncontroverted testimony at the lower court, Mr. Ramirez said that he hasn't used these workers, utilized any other workers since the date of the accident, February 2019. So that goes back to 2 years after that. We're here today. He hasn't.
And when he realized he had to start paying workers' compensation insurance, right? That's why he stopped hiring people.
Yeah, I didn't hear the first part of the question. I apologize.
He realized he had to start paying for workers' compensation if he was going to have employees. So that's why he stopped hiring.
I agree, Your Honor, but also the applicants testified earlier that I think at the hearing in January 2021, the first hearing, they've testified that the project was supposed to end at that time.
Okay. Isn't it true that the ALJ found your client not to be credible?
No, Your Honor. The ALJ found the testimony of the applicants credible, which any testimony that controverts that, you have to side by law with the applicants. So I don't think there's a finding, if I recall, that they specifically found that my client was not credible. Your Honor, so the dispositive question, I believe the ALJ skipped the entire analysis of the Section A of the relevant statute. Before engaging into the exercise of control and rights to control of the employees, I believe that the judge should have analyzed what are the hiring schemes of Ramirez Bros, what does it do in its existence, what did it do, at least go into putts and see what are the relative percentages of the 6 months they did work versus the 15 years in existence. There was no finding of that.
That's a scary hood to look under, though, isn't it? Because if one really looks at the employment practices of Ramirez Brothers, there are a lot of problems there. In addition to workers' comp, he was paying them under the table. You've all but conceded that they were not independent contractors, but they were employees. How, given that scheme of essentially illegal employment, are we supposed to credit Ramirez Brothers with having a unique employment scheme that somehow evades every law there is?
Your Honor, I think to answer that question, first, the issues that you just raised, Judge Swan, the other, I guess, impracticalities for this. Ramirez Bros is not a sophisticated business owner. If he has other questionable practices, that's the attendant risk that he bears, and that's something that's not before the court in the lower court, and the lower court here.
Well, I understand, but you're asking us to take this holistic look at the business from the day of inception through today and credit that with somehow giving Ramirez Brothers a leg up. It's difficult to do that. You're asking us really to take into account more facts than the ALJ did and more facts than are really before us. And my only point is, if we were to engage in that, it might not come out well for Ramirez Brothers.
I understand it, Your Honor. We're stuck with the facts we're given, but
yes, it's not your fault.
Yeah. No, if the court were to embark in that, and this is in our reply brief, I believe, if the court were to embark in that analysis, my position is that that's not outcome determinative, that is subject to the statute. It's one indicia of evidence, but it's not something taken as a whole, that he is affirmatively subject to the statute. And again, our biggest qualm with the lower court's decision, with all due respect to the lower court, is that the judge didn't even analyze any of the sections of Donahue, any of the Putts, any of the other progeny cases, in its decision upon hearing or decision upon review.
The language from Putts, the key language seems to be that no bright line rule exists, and then cautioning that there is risk involved when you hire others without getting workers' comp insurance. That doesn't seem terribly helpful to your cause. And then in Donahue, looking at the test now, the test is if the employer ordinarily does not regularly employ any workers, hires only occasionally and unpredictably. It seems that these two gentlemen knew exactly where they were going every morning, and they knew what they were going in. They were going in their employer's truck. That doesn't strike me as occasional or unpredictable.
Your Honor, I agree, but to add one step to that is these projects, again, give me some context. The projects, this is Mr. Ramirez, he's a landscaper handyman, if you will. These clients of his, the homeowners, would specially recommend these special projects, what I'm calling them, is that something that Ramirez Bros does not ordinarily do because he testified that he was too busy. So these projects may have lasted 1 week, 2 weeks, 3 months, 4 months. In this case, the burden's on the appellees to show which projects they worked on. I think what they did was just lump everything together into 1 6-month period without fleshing out which projects did they work on. If they would have done that, it's not our job to disprove that we're subject to the statute.
So if they worked on one big job, redoing a golf course, workers' comp. If they work on 16 smaller jobs doing people's backyards, no workers' comp. Are you saying that that's actually a legal rule?
Yes, Your Honor, I believe it goes to the unpredictability of those projects. And what I mean by that is, if an employer is assigning projects because the client dictates which projects to assign, that's outside the scope of what they normally do.
But this wasn't outside the scope of what he normally does. Nothing in this record would indicate any job was done outside what he normally would do, right?
Yes, Your Honor. I believe Mr. Ramirez testified that he could do the work, but he didn't normally do it because he was not, he was too busy doing the actual landscaping.
Well, he would hire people to do it for him.
In this particular case, yes, Your Honor, he hired these individuals. And again, which goes back to his intent. His intent wasn't to hire these individuals each time a client demand dictates it. It was because he was upset that these individuals did not have money to provide for their families. And that intent, I think, is important to analyze when you analyze whether or not this employer regularly employs employees in the course of its business. Your Honor, and to end, because my time is almost done, going back to the predictability of these projects, again, there's evidence in the lower court that these 4 customers at the time had dictated which projects they wanted to get done. In this particular case on the subject incident, I believe it was an irrigation work with some paver work that lasted an extended period of time. The incident happened. The day the incident happened, that's when the work was supposed to stop. And for those reasons, Your Honor, I believe the court erred in failing to analyze Section A of the relevant statute, and the decision upon, or the award should be set aside. If I have no other questions, Your Honors, I'm done with my argument.
All right, thank you very much. The matter is now under advisement. The court will issue a written decision in due course, and we will stand in recess until the next case.